Friends, we are going to start our 152nd Friday group meeting. Today's speaker is our Dr. Krishan Mahajan, one of the prominent personality as I advocate here, and ex-additional Registrar, Center for Research and Planning in Supreme Court Yard. So earlier occasion also he addressed on monuments. He was also presented a book to Friday group. In turn, we presented to library too. So I request. Thank you very much, sir. You came even though busy schedule
Welcome.
today.
Privilege
To be I request our Rahul Sharma will read sir CV of sir.
Dr. Krishan Mahajan has done fellowship from Columbia Law School, USA, Japan Foundation and Ramakrishna Mission. He is an ex-additional registrar of Supreme Court of India and headed its first research, planning and policy center. He is an advocate at Supreme Court of India and was appointed amicus in Taj Mahal protection case, bonded labor case, custodial death case, Jila Parishad cases and corporate merger cases. He was a panel senior central government advocate at Supreme Court. He has drafted parliament bills for the Ministry of Railways and notifications for several other ministries. He has taught banking laws, international trade law at Indian Law Institute and media law at Government of India's All India Institute of Mass Communication. His articles got published in various academic journals and he has authored a book titled Legally Victimizing National Monuments and Role of Parliament, Union Government and Supreme Court. Thank you.
Thank you. Thank you.
Now you can continue, sir.
Should we start?
Please, sir.
Thank you very much for finding time to be with us. The topic is victim compensation, and it's a huge topic. We are going to touch on the basic principles of victim compensation and not go into too much into detail, because then it requires a classification of the kind of cases in which victim compensation has been given. And that's a whole range of cases, including civil cases, matrimonial cases, criminal cases involving rape, and so on and so forth. Of course, custodial death cases. And I don't know whether you've ever felt after reading the Constitution of India or in the course of your practice, there seems to be a silent national policy of unaccountability. We seem to have a national policy of unaccountability. There is not a single word in the Constitution of India concerning accountability of anyone for violation of any part of the Constitution. So therefore, accountability, if any, is left to the courts. And courts are the sole judges and enforcers of accountability. And there we have come across a problem, a serious problem since 1950s. If you see most of the leading constitutional law judgments of the Supreme Court, especially under Article 32, Fundamental Rights, you will find that very, very few of the judgments have actually been enforced. Very few of the judgments. And even there it is doubtful how much of the enforcement has taken place. Now the question that arises is, why should I spend my money to come all the way to the Supreme Court and spend money on all of us to draft, file, argue, etc.? For what? For getting what? In terms of an actual relief. Maybe an interim relief I get. But is that the end of it? And then how many years I have to wait for getting or for coming to know as to what my final fate is? And the word used in 32, please, we often miss this word, is enforcement. Supreme Court, I don't come to the Supreme Court for declaration, like a declaratory suit for declaration of my rights. I come to the Supreme Court for an actual enforcement of my rights. And if that word is to be ignored by the Supreme Court itself, well, then there are serious problems for Indian democracy. And we are facing those problems. The question is this, that in the evolving, I won't use the word jurisprudence because that word is used too loosely. Jurisprudence is a whole philosophical approach, a conceptual approach, a thinking to the problem of enforcing fundamental rights. That is not visible, I am sorry to say, in any judgment of this court. It's just not there. The main thing about state lawlessness is that it produces victims, and sometimes it produces terrible victims. You have Union Carbide there as an outstanding example of the world's largest industrial accident. Until today, the compensation amount remains undistributed, unpaid, and God knows what has really happened. There are all kinds of reports that come from there as to who has taken away the money and how the affidavits have been organized, that money has been paid and all. And the affidavits are in a language which the signatory doesn't even know. So therefore there is a conceptual approach is required to victim compensation, and not a knee-jerk approach. Oh, this is what has happened, this is terrible. As states, we are supposed to do this. You reproduce the UN General Assembly principles of compensation, etc., for victims. And then you just announce a sum. You just announce a sum. There is no evidence as to how that sum has been arrived at. There is no there is no calculation, there is no principle on which that sum has been arrived at. And you just state an ad hoc sum. And what is worse is, when you state an ad hoc sum, you lay down not a single step of its actual received by the victim, knowing especially the status of the victim. The victim is a poor woman, is a child, is a person who is totally helpless, is a person who is innocent of the law. I mean, they don't know what are all the laws involved and what do the words mean, what impact legally they have in terms of his signing anything. And the worst thing is, all this would be tolerable. The worst thing is that those who have perpetrated that victimization go scot-free. Absolutely scot-free. For years together we had this principle which I unfortunately find being repeated now. Oh, you see, authority has been vested in such high officers of the state. How does that absolve them of accountability for what they have done? Just high officers of the state. I still remember Justice Fazal Ali used to say this. And then Justice Fazal Ali would say, oh, you see, such high officers, and his spectacles would, swing in the air. And but just the fact that you are a high officer doesn't mean that you are not to be held accountable because you are the Home Secretary or because you are the Chief Secretary. And that phraseology, unfortunately, has come back in some of the recent judgments. So this avenue of not holding anyone accountable just because you are a high officer of the state has no legal basis at all. As a matter of fact, the international law principle is the higher the officer you are, the more accountable you are, And now, after World War II, the international law principle is that you can't say, oh, my higher officer ordered me to do this. That is no defense. You will be prosecuted as much as of course, the higher officer. So, we seem to be slightly in a regressive mode as far as accountability of higher officers or even the highest officers of the state is concerned. Another pet phraseology to make these people free from accountability was, "Arey minister hai bhaiya, he is a minister. He is accountable to the people of India. He is elected." But how does that help? We are talking not of political accountability. We are talking of legal accountability and constitutional accountability. And if all of you remember the famous Rajasthan judgment, where the centre opposed the petitions imposing president's rule in 7 states in India after the Congress party had lost and the Janata government had come. And the Janata government said, look, the results at the centre show that this party has lost confidence of the people of India, and therefore it has no right to continue to govern in these 7 states where you have a Congress government. And the judges said, sorry, this is not how you impose president's rule. And the judges therein held that there will be constitutional questions will by and large be political questions, but that does not mean that the court will kind of run away from these questions, because the determination of constitutional questions is the domain of the court under the Constitution. So therefore the court will decide, howsoever touchy or politically sensitive or difficult these may be. This was several years ago, but somehow or the other, this silent, unexpressed doctrine of unaccountability seems to be running through the court judgments, and there seems to be no movement or no opposition to it. And if there is no opposition, then we'll continue to get ad hoc judgments. एक केस में कुछ हो जाएगा, दूसरे में कुछ हो जाएगा. All of us know, in terms of precedents, for every proposition you can find an opposite judgment almost. Now, this is what has happened to victim compensation also. I'm not going into 357 CRPC, which all of you know, I mean, doesn't need, and which now has been, in a sense, superseded by the NALSA report and recommendations on victim compensation directed by this court, and which have been made enforceable. The problem is that, you see, our country's problems are very different from the models that are followed by this court. The models that are followed is United States model, or maybe some other country's model. If it takes the judge's fancy, a European country's model. Sometimes the Japanese constitutional model. What the problems that we have here exist in no other country in the world. It is as simple as that. And we won't be able to find solutions to problems which do not exist anywhere else by adopting their models. And if you see any of the recent judgments, right down from the privacy judgment onward, I mean, you ask the ordinary man in the street, or the woman in the street, or the child in the street, उसको क्या लेना देना है US Constitution ने क्या कहा नहीं कहा, because he knows what there is. In a sense, firstly he wouldn't understand this word privacy. ये क्या होता है? The Indian way of living is not the United States way of living, and this privacy notion is a total alien concept, completely alien. हमारे होती है privacy, but privacy is understood in a different way, completely different way. Privacy हमारे होती है नज़र की, privacy हमारे होती है देखने की, privacy हमारे होती है बातचीत की, किससे बातचीत कर रहे हैं, बहन से कर रहे हैं, सास से कर रहे हैं, बहू से कर रहे हैं. Privacy is in that sense, you know, and we are not taught privacy. We are brought up in a certain way, manner of addressing, talking, dressing, doing things, living together in a house, what to do, what to avoid. So you see the legal route or the constitutional route or the structure which is being erected on the basis of these has really no relevance to the life in India. Has really no relevance at all. So, accept that maybe you and I are affected. We are a microcosm of India's population, hardly significant in terms because we have monetary strength and we have voting, of course. But otherwise, in the totality of India, we are just a speck. And for this speck also, what is it that you are guaranteeing? Are you guaranteeing timely, effective justice on any score? As a matter of fact, I mean, except for lawyers like many of us who practice across all laws, all courts, all over the country, even as lawyers, we are afraid to step into the police station. You don't want to go there at dead of night with a client and say, Ki. So, the ethos, the cultural ethos of India is so different that it doesn't fit in or gel with the constitutional ethos which is sought to be planted here. It simply doesn't work, it won't work. And unfortunately, this is what has happened right from the Constituent Assembly. In the Constituent Assembly, you know, B.N. Rao, all the constitutions were studied and all. And then these models were proposed, article by article. Some articles were not even discussed. Some were not even, formally tabled and then just gone through. The victim compensation is, who is a victim? That is the question. And how much time will you take to find out the victim? And B, what will you give to the victim? As a supportive mayor, as a rehabilitative mayor, and above all, as a protective mayor, so that out of vengeance, those against whom the relief has been given won't come and snatch it away with worse consequences. And those of us who have worked with the law in the field also and travelled villages right across India, from hamlet to hamlet, kasbah to kasbah, you will realize that the retribution is very quick and fast. And there is no remedy against the retribution. So now I'll take you, if you permit me, I'll take you through the first one, which is it a problem?
Cross.
Yeah. This started with the famous blindings case. Bhagalpur blindings, all of us have heard about it. Indian Express started off the whole thing. And then the public interest litigation was filed on the basis of those newspaper reports from Bhagalpur. And the case that came here was Khatri 4, Khatri within brackets Force versus State of Bihar, 1981 to SCC 504. Now, in this, the compensation argument was put forth, and it was said it is obvious that they have been blinded. Their FIRs state that at the time of arrest and then later on within the jail, their eyes were pierced with iron rods, and then into the holes that were dug into the eye, acid was poured. I don't know whether this is enough to shock the conscience of the court, because we'll come across that phrase later on. Now, the foundational fact was that can you order compensation without first establishing these facts? That these policemen in Bhagalpur, they did this. And then that the jailer connived or participated or was a silent spectator in this. And the court was very, very clear that this foundational fact has to be established. Until then, we can't give compensation. So all that was done was the treatment was ordered at the AIMS Rajendra Prasad Ophthalmic Center. First, the Christchurch and then the Blind Relief Mission here on Mathura Road. They were asked to house them and feed them and look after them. And the expenses were directed to be met by the state of Bihar. But after that, another question arose. The investigation had been handed over to the CBI, and under the Police Act, 1861 or whatever it is, a very senior officer had been directed by the Bihar government to hold an investigation into these 24 cases of blindings. LV Singh or somebody. He filed the reports. The reports were before the court. And of course, the objection was taken that none of these reports can be relied upon. To which the answer was very simple, that a public officer creating a public record, Evidence Act, a relevant fact is there. So therefore this can be looked into by the court. Fair enough. But when the question of giving them some relief came, the relief was zero. No relief was given to them. Not one single paisa of compensation or even of interim compensation to look after their needs, so that you could adjust that compensation if necessary later on with the final compensation. So there you are. And of course you have a great lecture about fundamental rights and how fundamental rights have to be protected by this court, and the court is the sentinel of these fundamental rights. Went on. So nothing happened in this. The thing was that if the court had these reports of a designated officer asked to do this job, and if the court had the reports of the jailer also, then why did the court simply keep silent of these reports and not order something? Okay, that's fine. Now, in terms of the court order, a trial will have to go on, and the trial will have to establish that foundational fact. Not a single direction about an expedited trial. Not a single word on an expedited trial. That there should be a time-bound trial, within this much period you must finish, and no direction that please keep on giving us the reports at these regular intervals about the trial. So you monitor the whole thing. So that's where it ended. So you have the famous Khatri 4 case of Bhagalpur blindings, giving you nothing in terms of the victim. Then we came to Rudel Sah versus State of Bihar. Now this is an extraordinary case of victims. Rudel Sah was a young lad, picked up, thrown into jail, Bihar. and he was acquitted finally. After that long period in jail, he was acquitted. Even, do you want the citation? 1983 4 SCC 142. 1983 4 SCC 142. Now Rudel Sah, somebody he must have caught somebody's attention, but finally a petition was moved here that even after acquittal, he's still inside the jail. And then the net result was that he was, after notice from here and all was issued, then the machinery started moving. But for 14 years after acquittal, he stayed inside the jail. And he was released, of course, because that's the affidavit immediately the Bihar government filed. Oh, ab to humne usko release kar diya. So, we have washed our hands off, so you please shut down the proceedings here. He's been released. और क्या चाहता था? Then the court started going into this whole series of events on which the affidavits were before the court, and in these affidavits clearly showed that the reports had been sent to the reports had been sent to the law department, and the law department was to issue the order of release or direct his release to the relevant authority. The law department, at least for 7 years after his acquittal, kept quiet. तो कोई law secretary है कि नहीं है बिहार में? मतलब I guess in all our states we have a law secretary. Apart from a chief secretary who is supposed to be watching what his secretaries are doing, and so as an ultimate defense they said, ये पागल था, इसलिए इसको नहीं छोड़ा. He was insane. So the court said, okay, but then the court found that the civil surgeon had said that no, he was never insane. Now, they had no answer to this. And therefore, again, you get very nice paragraphs, beautiful literature, English literature. We use that sometimes while teaching law and literature in terms of the language and the power of language. And Chief Justice Chandrachud was a master of language. Some of his, I would request you to read Olga Tellis, how in about 4 paragraphs India has been summarized. Beautiful. The thing is that after all this finding on affidavits and in writ petitions, we know that you have only affidavits, you don't have witnesses and examination, cross-examination, etc. Where is the accountability? The court kept quiet. On affidavits, you have everything that you need to have. You have the civil surgeon's report, you have the affidavit of the other participants in the whole drama. It was a good occasion to go into prison administration. It was a good occasion to go into the duties of the district judge as a visitor to the local jails. Why was he not going there? You should have pulled up the district judge at least. You should have called him and said, please file an affidavit. Please show us that you have been discharging your duty. The question is not of punishing the district judge or punishing. The question is of accountability. That you have a statutory duty to perform. That statutory duty protects the fundamental rights of the citizens, and you are not performing that duty. And therefore, every district judge now has a leeway कि अरे यार नहीं करेंगे तो क्या फर्क पड़ेगा. And this is, unfortunately, this is what is going on, whether it is Delhi or whether it is some other place. So the court had full power to lay down accountability in terms of existing statutory provisions available concerning prison, existing statutory provisions available concerning tortious liability. and it would have led to the immense development of the law of tort. Total silence. So that's why I say there's a conceptual vacuum. You see, in terms of the legal approach in such cases, you don't even talk of tort. You don't talk of prison administration. You don't talk of the duties of a magistrate at the time of production or remand. You don't talk of all that. So at least आप compensation नहीं दे रहे, या आप एक pitiable compensation और a pathetic compensation दे रहे हैं, पर at least system तो ठीक कर रहे हैं. At least the statutory system is being made workable. So, and all of us, I don't know how many of us have a real hard experience of the lower courts. You take negotiable instruments. Number of judges keeps on increasing. Number of arrears keeps on increasing. Why? Why? और ये कहाँ का असूल है एरियर्स के में? बड़ा सिंपल है. इन ए कॉर्पोरेट सेटअप, विल यू क्वेश्चन कि मेरे पास मैन पावर नहीं है? विल यू क्वेश्चन? आपका काम नहीं हुआ तो आप घर नहीं जाएंगे. सिंपल. इट्स सिंपल. आपका काम खत्म नहीं है, आपका काम है तो आप क्यों जाते हैं? हाउ कैन यू गो टू स्लीप इवन व्हेन योर वर्क इज नॉट ओवर? Are you some special human beings that you can say, oh, you know, we work from this hour to this hour, from this hour to this hour. We can get up when we want, we can go when we want, we can go abroad when we want, we can... This kind of license it doesn't impress anybody. And this kind of license is not available in any other country in the world. Please, with all due forgiveness. This England में, I've been with judges. In the evening, the secretary of the judge will leave at 5 no matter who you are. And then she would have taken out the files for the next day, kept it on the table, and she will say, thank you, जा रही. फिर आप अपनी फाइल्स अपने आप उठाइए, आपके साथ कोई नहीं जाएगा. You will go to the nearest metro जहाँ से आप रोज़ मेट्रो पकड़ते हैं, और आप अपनी फाइल उठा के घर जाएंगे. Why can't you live like ordinary human beings? This British introduced system of, एक काफिला लेके चलना और impression, all the public. Which public? You are not giving no relief to the public. So, if you go to Britain, please visit the Old Bailey, the criminal courts, please visit the civil side, please visit the constitutional benches, the equity courts. You will find, ordinary, and you just send in a request, the judge will call you and meet evening. And if you sit with him and spend about an hour and a half, he will say, look, I must go now, tomorrow's cases are there. वो अपनी फाइल उठाएगा, मेट्रो तक जाएगा और अपने आप घर चला जाएगा. The ecosystem that we have created is a system where unaccountability ultimately finds its root and its destination, final destination, in the courts. So how can you expect such people to introduce accountability? क्योंकि वो बहुत ज़्यादा accountability करेंगे तो उन पे भी फिर accountability का counter आएगा. So this Rudel Sah again, इसको compensation मिला 35,000. Whole of his youth he spent in jail. It is admitted that he was wrongly confined. It is admitted that law department wrongly did not order his release. It is admitted that the defense put forth is wrong, insane, and yet 35,000 rupees. And then, not a word. He is illiterate. He has nobody to look after him. वो जेल से बाहर निकल के क्या करेगा? He is a sitting duck for victimization further. And with that money, और वो पता नहीं उसको money मिला भी नहीं. Not a word कि somebody should ensure that he gets that money. Or that money be put in his name in a bank account, or a bank account be opened in his name. Not a single word. Is this how you ensure fundamental rights? I mean, surely these judges know, and incidentally, many of these judges have been first-rate trial criminal lawyers, including the famous Nanavati case. But एक word नहीं about ensuring that Rudel Sah gets his money, that the money remains with him, and that there is somebody to tell him what to do with the money, or overall guardianship कह लीजिए उसको, जो भी कह लीजिए. So, what's the use? I mean, of all your experience in criminal law, first-hand experience with trial courts, traveling with criminals in the same buses as an assistant public prosecutor, etc., etc., what's the point? So, ये इसको 35,000 after all this. Then the third case is, and look at the language used. The violation of 21 can be prevented, due compliance with it secured by court, mulcting its violators in the payment of monetary compensation. What's the point of writing this in Rudel Sah? You're not mulcting this is at page 147, para 10, if you want it. State must repair the damage done by its officers to the petitioner's rights. The whole of your life you have been incarcerated for no good reason behind jail. Lies are told on affidavit in the court that you are insane. Civil surgeon says you are not insane. And then, which officer of the state has been asked to restore the damage done to his rights? None. But the statement of law is there. State must repair the damage done by its officers to the petitioner's rights. Then an interim mayor to pay 30,000. 5,000 had already been paid. In addition, 30,000 to be paid. So 35,000. The government of Bihar to pay. So nobody is held accountable. Public money is used to satisfy the court that we are paying. We recognize the order of the court. No official is. And what is the basis for interim compensation? How do you decide that a young chap who spent the whole of his life in jail on absolutely wrong reasons, admittedly wrong reasons, on affidavit, is worth 35,000? That's all. And then the court found that the jailer was being made a scapegoat for the higher officers who were guilty of dereliction of duty. But who were the higher officers? अब ये इतना लिखने से क्या फायदा? What is the point? You see, the message then that goes, and please, I mean, all of us know that senior administrative officers are very highly educated, brilliant officers. They are first rate. Now when they read this, तो वो हंसेगा नहीं. वो कहेगा ठीक है लिखने दो. क्या फर्क पड़ता है? Dereliction of duty, but which officer? Nobody. So the message that goes across is that unaccountable रहो, कोई फर्क नहीं पड़ता, ज़्यादा से ज़्यादा कोर्ट ये लिख देगा. No problems at all. Made a list of. Then the next case in 1983 was BC Oraon Tribal, O-R-A-O-N. Now he was an under trial. He was detained for 6 years in a lunatic asylum after he had been declared that he was not a lunatic. After he had been declared he was not a lunatic. And he was certified as being fit for discharge. Yet for 6 years he was kept in there. Again, usual affidavits वगैरह सब कुछ है. but no compensation. No compensation. So victims are there. They are staring in your face through affidavits of the government machinery, but no compensation. Then comes a astounding case of Sebastian Hongre, Sebastian Hongre versus Union of India, and this is an extraordinary case. 1984.
So can you repeat first one?
Which one? Sebastian Hongre. Sebastian, Sebastian, Sebastian. Hongre, Hongray, Hongre. 1984 का है, मेरी लिस्ट से निकाल. I made the list. We'll use this. Sebastian Hongre, Hongray versus Union of India. Now this was the 21st Sikh regiment stationed in Manipur, and Manipur, you know, is an insurgency area. So this Sikh regiment, the wives of two persons there. One was the headmaster of a village school, Ukhrul, and the pastor, वहाँ का पंडित कह लीजिए उस गांव का, and they were taken. This much is there that they were taken by the Sikh regiment soldiers to wherever, to their camp, and after that they disappeared. There was no trace of them. So the wives moved the Supreme Court, and notices were issued to the Ministry of Defense, Ministry of Home, the Sikh regiment. The first affidavit पे reply क्या था? We don't know where they are. They can't be traced. What a reply! I mean, so court ने थोड़ा सा push किया. Then comes the second affidavit. Yes, you know, they came to the camp, पर हमने उसको उसी शाम छोड़ दिया था. We had released them that very evening. अब वो रास्ते में जंगल है, कोई जानवर खा गए या कुछ खा गए. We don't know. So again, I mean, neither here nor there. So then now the judges were a bit more active in getting the evidence at least on this. And they said, okay, get us the records of the Sikh regiment camp there. Records they find the records were interpolated. The entire records were interpolated. So they lost all credibility. And then they said, well, we had issued a writ of habeas corpus. Instead of producing them, you are telling us all kinds of things. I mean, you know, we don't know where they are. Then you say they disappeared. Then you saying.
So I took permission. My matter is about to reach.
Oh, please.
Please, I will attend and will come.
Please do.
And Justice Karpaga Vinayagan dwelt seriously on this 357 as a judge, Madras High Court. He want to say a few things.
Please, most welcome.
Reported judgment. At the end, you want to give some citations.
Oh, lovely.
I will come back, sir.
Lovely. It will be very valuable for me also. Thank you, sir. Thank you for coming. Thank you. So then these, they cited them for contempt, civil contempt. Not criminal, civil contempt. So they said, now what can we do? The Ministry of Defense files an affidavit saying, we don't know. The regiment says nothing. The Home Ministry says, we don't know. So then they said, well, we can, under contempt law, there are only two punishments, either jail or fine. But this is a civil contempt. Then I don't know, there is no logic in the judgment as to how it was worked out. But they said, we'll impose exemplary costs, that's all. The word compensation was not even used. Will you impose exemplary costs? An exemplary cost, I think, of 1,50,000 or 1 lakh each to the two widows were given. And that's where the matter ended. Along with that, they directed the SHO of Ukhrul to register a cognizable offence of murder and launch an investigation. Again, nothing. Within how much time you must, or that you must report back to the court what has happened. Because if you are enforcing fundamental rights, you are supposed to keep a tab on it, or at least put a bit of a fear in the local authority that, look, somebody is there watching. Oversight ho raha hai. Nothing. So there you are. The money was, I hope the money was given. 1 lakh to each widow. Cognizable offence of murder, SP Ukhrul, Manipur, and no time, within how much time investigation should be completed, or reporting to the court, or that the court should be told that a charge sheet has been filed, or a trial to be completed. Nothing. Then the next is State of UP versus Ram Sagar Yadav. 1985 1 SCC 552. 1985 1 SCC 552. Now, 552, page 552. Now, here, the sometimes you laugh at the offence, but then your laughter stops because of what has happened. Cattle trespass. विलेज है, गांव है, फार्मर्स है, कैटल ट्रेसपास का केस फाइल कर दिया किसी ने. somebody filed a cattle trespass case. So this man Brijlal, he was approached कि अरे इतना पैसा दे दो, केस बंद करवा देंगे, we'll get the case closed. So first time he gave some money, but then that policeman from that station, he thought कि ये तो perpetual source of income है. He went there for a second time and he said, now you give me, first time you gave me 100, now you give me 200. तो इसको गुस्सा आ गया. इसने कहा भाई पहली बारी इसीलिए दिया था ना, केस would be closed. Now you want again, you will come again. So he made a complaint to the SP for having the daring to file a complaint against a policeman. The SHO of the police station कहा होगा कि इसको उठा के ले आओ. He was brought to the police station, mercilessly beaten, and then foolishly enough, I mean, you know, they moved an application for remand. अब remand में तो produce तो हो गई. The presiding officer was very good. You see, this is where even one good officer, not armed with fundamental rights, jurisprudence and all this, but just observing statutory law can do a lot of good. He had finished his day's work. He was getting up and जो normal होता है कि भाई और कुछ है, तो उसने पूछा, तो उसके हेल्पर ने कहा कि हाँ साहब एक ये रिमांड की एप्लीकेशन. तो उसने कहा रिमांड की थी पर वो है कहाँ. तो उसने कहा सर ही इज़ लाइंग इंजर्ड इन द कॉरिडोर. द प्रिसाइडिंग ऑफिसर वॉक्ड डाउन टू दिस मैन Brijlal, talked to him. Initially, because he was so seriously injured, there was a problem in getting his response, but he was diligent enough to pursue, sit there and talk to him. And then it transpired that this is what had happened. That ये सारा किस्सा जो है उसको, and he recorded it. He recorded it, he signed it as a judicial officer और उसको record पे रख दिया. Now, again, petition was moved here, and in the meantime, the trial court convicted them under 300 Part 1, not 302. The Allahabad High Court acquitted them. So they came here. Now when they came here and the judges saw, and they said all this evidence, there is a dying declaration, because after that Brijlal died, after the judicial officer had got signed the statement. So he said there's a dying declaration duly recorded. What is? So then the question was again, ki what can be done for him? And again, except for this, that the charge was that 302 का charge लगा दिया, उसको elevate कर दिया. No compensation. No compensation. But nice paragraphs sort of fundamental rights and protection of life and liberty, great constitution is promised. No compensation, not a paisa of compensation. Then we come to another interesting case, Bhim Singh, 1985. If you don't mind, at the end I'll give you the citations. I put all the, it was a long list of cases, so I thought it would be convenient to put all the citations in one place. I don't know where that page is gone. So Bhim Singh was an MLA. Bhim Singh was a member of this bar. I hope all of you know this.
Professor Bhim Singh.
Professor Bhim Singh had founded a small Panthers party in Jammu and Kashmir, and then he was a bar at law from England, and used to appear very frequently here. He's no more. Then Bhim Singh was an MLA, and he had been suspended by the Jammu and Kashmir Assembly. So he went to the High Court, challenged it. High Court granted an interim stay against the suspension. So he said, fine, now I'll go and attend the assembly. So those were August or so, summer months. So the assembly was in Srinagar, not in Jammu. So from Jammu, he said, I'll travel now to Srinagar to go. So obviously word was quietly sent through the police channel कि इसको नहीं जाना देना वहाँ. He should not reach the assembly. So consequently, he was detained at police station A, and then at police station B, were remanded for 2 days, क्योंकि वो 2 दिन रहते थे for the assembly to begin. But they saw to it that he did not reach the assembly. So in the meantime, his wife, who was also a lawyer, very brilliant wife, she moved to the Supreme Court, and she said, but where is he? ये तो बताओ वो है कहाँ? आपने अगर उसको अरेस्ट किया है तो उसका कहाँ उसको रखा हुआ है, क्या हो रहा है? And then of course वो immediately the additional sessions judge ने फटाफट उसको बेल दी और वो फ्री हो गया. Now he filed his own affidavits, and he said all these police officers are telling a bunch of lies. I was never produced before any magistrate, and I never gave a medical certificate along with an application to the concerned executive magistrate. And if they are saying all this, then produce those documents. वो documents produce करिए ना, वो आप court proceedings की बात कर रहे हैं. No documents. But the IG Police Kashmir, he filed an affidavit, and the SP concerned, he filed an affidavit, and the two affidavits contradicted each other. And the court said, obviously we'll believe the IG Police was a believable affidavit या जो भी है, but the court chose to rely on this. And then the question therefore arose that his detention was utterly illegal, and it was, if I remember, Justice Chinnappa Reddy's judgment. Chinnappa Reddy's judgment. And he, wrote categorically. He said that there is no doubt from the documents on record that the police made its utmost attempt at the behest of the state authorities to prevent him from joining the assembly. Clear हो गया? वही life, liberty lecture. And ultimately, what was he given in compensation? He was given compensation 1 lakh. That is all. So now, when an MLA is detained and the documents are before you, but when Rudel Sah is detained and again the documents are before you and both are clear, look at the compensation. 35,000 and 1 lakh. तो जिसको कहते हैं ना मापदंड तोलने का क्या बेस है? How do you decide compensation according to the position that the person is holding? Because in criminal law we have you look at the offense, not the offender. And similarly, you don't look at the status of the victim. He is a victim. He is a legal victim. And in terms of the law, he is entitled to certain legal rights. So this again shows you what's been going on. Then came the famous oleum gas leak case, Shri Ram Industries, MC Mehta versus Union of India, 1987. Now in the oleum gas leak case, I don't know, many of you may not be present when that happened. Seshu,
Yeah, I was there.
you were there. 7 बजे कोर्ट बैठा था यार. कोर्ट नंबर 1 में 7 बजे शाम को और रात के 9:30 बजे तक यहाँ कोर्ट चला और डेस्परेट सर्च फॉर एन एक्सपर्ट साइंटिस्ट कि हु इज द एक्सपर्ट साइंटिस्ट whom we can get for this. सब कुछ हो गया. Strict liability for any industry storing hazardous substances. So you're liable, no need for proving. You're storing hazardous substances, it's your business to take care that people are not harmed by what you are storing within your premises. But question ये आया कि is Shri Ram industry subject to fundamental rights? तो उसमें भी अल्टीमेटली बहुत अच्छा लेक्चर आया कि you see industries damages must be assessed according to the size of the industry. कितनी बड़ी है, टर्नओवर क्या है उसका, सब कुछ बहुत अच्छा है. Then the question was that जिन लोगों की life and liberty who have lost, and there were lawyers who had lost their lives because there was a stampede that ओलियम गैस इज कॉन्सेंट्रेटेड सल्फ्यूरिक एसिड के फ्यूम्स जो हैं वो हवा में बैठे रहते हैं तो वो डिसेंड करते हैं आहिस्ते आहिस्ते. Many of the lawyers in G.Seshagiri and other places, they lost their lives in the stampede to run out. Cases फाइल हुए थे, सब कुछ था. हाँ, तो ये कहा गया कि भाई इनके लिए कोई तो स्पेशल मशीनरी बनाइए कि फटाफट इनके केसेस डिसाइड हो जाए. आप फैक्चुअल फाउंडेशन चाहते हैं ना, so let each one of these victims come and prove through that special machinery that this is the harm to me, this is the extent of harm, I was here. That person, especially a lawyer, will put all documents before you. They refused. They turned down the prayer for a special machinery. Even the lawyers were involved. Kuch nahi. I mean, we are not asking that we be recognized in terms of our status as victims. But the point is this, that if you keep on talking about, camaraderie between the bar and the bench, is this the sort of camaraderie you want? कि जब disaster strike होता है तो आप भूल जाते हो camaraderie. So nothing happened in that. No compensation. No compensation. And then you come to Saheli. Saheli versus Delhi government. अब इसमें बड़ा simple landlord tenant case था. The woman's husband was a truck driver and so he was not at home. And this landlord had been asking them to get out of the house. खाली कर दो घर. नहीं हो रहा था तो उसने सोचा कि husband तो है नहीं है. तो he, according to the language used in the judgment, he trespassed into the woman's house and hit a brick on her head. Kamlesh is the woman, on her head. And then he took her infant and threw him and banged his head on the wall. फिर डेंजर हो गया, फिर वो लेके गए सारा कुछ. Now this case would not have seen the light of day except that there was a very upright police commissioner, deputy police, क्या होता है, deputy police commissioner, Kamaljeet Diol, IPS. She saw to it that the investigation was thorough. The wrongdoers were pinpointed in terms of the evidence, collected all the evidence, including that of against her own policeman, and filed it in the magistrate's court. And on that basis, these people were given a compensation, and the compensation क्या है? 75,000 for the loss of an infant. Again, no parameter. How you have come to 75,000? वुमन की इनकम क्या है, उसका हस्बैंड क्या करता है, इनका पॉवर्टी स्टेटस है या नहीं है, क्या है, कुछ नहीं. So Saheli was disposed of. Then you come this is 1990, 1991, Ravikant S. Patil versus State of Maharashtra versus Ravikant S. Patil. Now maybe Ravikant was known a notorious criminal. तो इसको पुलिस ने पकड़ लिया and ले आए इसको, और and then the police did something. They published in the local newspaper कि इस तारीख को हम इस क्रिमिनल को परेड कराएंगे through the streets and the route will be as follows. which is against all canons of law. I mean, you don't do this to under trial prisoners. तो उसको almost naked, वही चप्पल वप्पल पहना के, and drum beats, they organized the drummers also, और drum beats के साथ he was taken through the streets. I mean, it was made into a spectacle in which people were watching from balconies कि भी क्या हो रहा है. And so the High Court gave him compensation, minimal 10,000 rupees. 10,000 की compensation दी इसको. But strange, the Maharashtra government appealed against that to this court. And the Maharashtra government, look at the defense, you see, they said that he is an officer who was carrying out his duty. And therefore, while doing his duty, if this was not part of his duty, how can the government be held accountable for it? Strange. अब affidavits सब आ गए. तो the court, now this is the problem. When you don't give reasoning in a judgment, then those judgments can be used the other way around. The court cited Rudel Sah. And the court said, oh look, in Rudel Sah also the officers were not held accountable. ठीक है, बात ठीक है, nobody was held accountable in spite of all the reports before them. So they said here also, no accountability, was. And that the Supreme Court disposed of the case in this. This is Ravikant, this is Patil. And then of course 93 you have Nilapati Behra, the famous case. And now Nilapati Behra simply said that there is a strict liability to pay compensation. That is all. They converted it into a strict liability for violation of fundamental rights. But then where does that leave you? You are unwilling to find a violation when all the affidavits and documents are before you, when the admissions virtually are, there are admissions before you of the officers. कि हाँ ये हुआ है. And you are unwilling to hold the system accountable or anybody in the system accountable, or to suggest a change in the system or organization, or to even ask ki what are you going to do about it, change in the system, or to give compensation. And in Nilapati Behra, usko compensation was given 1.50 lakh, and for the killing of her son, who was picked up and taken to the police station And then next morning he was found dead on the railway track. And the police said, what can we do? We brought him. His hands were tied with a rope. And the hands were behind him. They were tied behind him. But he chewed through the rope. This is, he chewed through the rope and ran away. So he died. Now all that was found to be wrong. And then they said, ये train accident से मर गया. But the post-mortem report, doctor was honest. He said, no, this death is not due to train accident. This death is due to being thrown or falling over the railway track. About it. And that's where the matter ended. This guy. So I was, when I was doing this, preparing for this today's lecture, I was wondering कि this seems to be a thought process in the Supreme Court. So I went back to my good old judgments, Gopalan and all that. And actually, there's a striking resemblance with those judgments. Gopalan में आपने कह दिया कि no, you see 21 नहीं, 21 अलग है, उसको अपनी जेब में अलग रखो, very precious. हाँ, 1914 अलग है. So preventive detention you can't challenge under 21. You can't challenge. Of course, our constitution, हम कहते हैं ना कि we have the largest constitution in the world, democratic republic and all that. We are the only constitution of the Anglo-Saxon world, of the Anglo-Saxon countries, having the similar legal structures, which has a provision for preventive detention in the constitution. No other constitution has it. England question doesn't arise, USA question doesn't arise, Canada, Australia, you don't have this preventive detention provision. Those of us who read judgments and try to look into the political history of that time, very essential to understand the judgment. Gopalan had become a thorn in the central government's neck because he was a trade union leader and he had organized the trade unions. So now this thorn had to be taken out and the elections were coming. So district magistrate को कह दिया इसको उठा के अंदर कर दो, preventive detention. So the thing is that this paradigm has been going on since Gopalan. Then you had Bombay, State of Bombay versus Kathi Kalu Ugad, a tribal, 1950 again. And here the Supreme Court said that self-incrimination fundamental right is only if you are compelled to self-incriminate. So therefore, suspects are out. So suspects को पुलिस उठा के पिटाई करके मार पीट के उनको बाहर फेंक दे. उसके बाद वो बोला suspect, no self-incrimination. And mental compulsion is also excluded. Janardhan Reddy versus State of Hyderabad, right to counsel. You don't have a right to counsel during custodial interrogation. State of Punjab versus Ajay Singh, 1953, illegal arrest is not covered. And then all of us know the emergency and the Shah Commission report. And then his verse is in R.M. Malkani versus State of Maharashtra. The Supreme Court, and this is a lot today still, stolen evidence is admissible evidence. And then Puranmal, famous income tax judgment investigation, it was argued that in a search and seizure, the evidence that you collect by force is tainted evidence. They said, no, maybe tainted, but tainted evidence is admissible. Nandini, right to presence of counsel during custodial interrogation, now there 1978. Sheila Parse versus State of Maharashtra, custodial violence on women under trial prisoners. No relief. Raghuveer Singh versus State of Haryana, 1980. Torture and murder of suspects. Silence. So this is not that this is suddenly they came to compensation, they started announcing, oh, our founding fathers would have been aghast, that no compensation is paid for violation of fundamental rights. And then of course to Neelabati Behra, where they said interim compensation bhi hum de sakte hain. And in Neelabati Behra, mind you, they said the compensation given by us, by a court under writ jurisdiction now, will be set off against any compensation recovered under the civil proceedings. So मतलब वो, even if that person knows that in addition to the compensation, I can file civil proceedings and get a larger compensation, firstly that person wouldn't know this, कि civil proceedings unless there is some lawyer helping him. And that person would be afraid that suppose the civil proceedings compensation are so small that if this is deducted, I'll be left with nothing. So I don't know. इसके बाद तो internally one is afraid कि life and liberty जो है वो can I really come and get myself protected except for an interim order? Bail, अच्छा हाँ होगी नहीं होगी, anticipatory bail होगी नहीं होगी, except for an interim order. And therefore this is very unfortunate that a fundamental rights court has become basically an interim orders court, which all of us know. It has become an interim orders court. आप interim order ले लीजिए उसके बाद ठीक है जयराम जी. So this is I conclude here. I am sorry I have overstepped my time.
No.
So any of you, any questions, sir, please.
I request Justice Karpaka Vinayagam, whatever judgment you delivered, reported, can you find out that on victim 357, sir? Can you remove that? Can you remove that?
That will be great.
You can focus it on sir. You give it to sir. No. You sit, sir. You sit. Please.
No, sir.
You will sit.
Sir, please.
No standing.
Sir, please,
I alone won't stand.
Sir, please sit, sir.
Please,
Please.
Okay.
Sir, Krishan Mahajan.
Sir, please, sir.
Sir,
Please cover.
main construction is by Mahajan.
No.
I am only additional construction.
No, sir. but vital construction. The main construction will fall.
The point is, they're all polishing. As far as trial court is concerned, construction. The appellate court, up to Supreme Court, polishing and painting.
Absolutely.
That's what we do.
Absolutely right.
But I have given some judgments of mine when I was High Court judge of Madras High Court. I had to deal with the section 357. Till then, I did not know the importance of 357. There are some important sections, CRPC 154 FIR, a 204 summons, a 208 committal, and 311 recalling witnesses, 313 statement, and conviction, all these things and all. But I did not just look into the speciality of 357, victims' compensation. Nobody take care of the victims. The person who has ignored his victim only. The person who is interested in getting acquittal or sentence and all, accused alone. Only he has been given opportunity or power to argue. They engage a rich counsel. He becomes, as soon as the case is over, advocate will become rich and the accused will become poor. But point is, what is the importance of 357? 357 contains three parts. One is, when a fine is imposed, out of the fine, one amount can be given to the victim by way of compensation. One. Number two, even if not fine is the part, no part, we can impose compensation to the accused to be given to the victim, even when fine is not imposed.
fine is not imposable. But even when fine is imposable, you can impose compensation in addition to the fine. That's a specialty. These are the difference, subtle difference. And you must see that.
Thank you, Justice Karpagam Vinayagam sir. Thank you, Mahajan sir. Very nicely you explained everything. It is compensation by Supreme Court's various judgments. And
I don't know.
now finally I request Subha Pandey will give vote of thanks.
I would like to take this opportunity to thank sir on behalf of all of us. Thank you, sir, for giving us the opportunity to audience you today. And also thank you so much for giving us enlightenment over the topic victim compensation and the accountability, which is most ignored today. We would like to have you for next many more sessions here.
We will love to.
And
I'm always with you.
We are looking forward to meet you again in the Friday group. Thank you so much on behalf of everyone once again. Thank you.
Can you read Subha this message quickly?
Friday group is a necessity for making the Supreme Court judgments meaningful, wonderful, brave and pioneering institutional work by dear Seshu and the group.